Most people think that once they're arrested, that criminal charges are unavoidable or inevitable, and that's simply not true. Hi, I'm Nano Knight, and I'm the CEO and founder of Knight Law, and I've been in a courtroom for over 16 years, first as a prosecutor and now as a criminal defense attorney based in San Jose. I'm also a certified criminal law specialist certified by the California State Bar Board of Legal Specialization. If you've been arrested for a crime in California, that does not automatically mean that you are going to be charged in criminal court. Remember, the officers who arrested you do not have that authority to file charges against you. What they do is they investigate the case and they take down witness statements, they gather and collect evidence, and they compile it in an investigation and a police report that gets handed over to the DA for a decision on filing. If you're proactive to leverage this feature in a criminal justice system that's called pre-filing diversion, and the name speaks for itself, it's pre-filing, which means that you have an opportunity to intervene and request that charges not be filed against you in exchange for the performance of certain things to earn that diversion, right? So what this means is if you're arrested for low-level crime, for example, your defense attorney can immediately engage with the prosecutor and provide some favorable background on you, your family, your career, your accomplishments, highlighting the lack of criminal history, highlighting the facts of the case and your defense in a written sort of document and a timeline that shapes the narrative in a way that's helpful for you that the prosecutor might not have been aware of, and basically advocate for you and request that you be granted an opportunity at pre-filing diversion. And we've had many cases where we have intervened right on time before the DA or the prosecutor had made a decision on what charges to file and whether to file charges, and that extra information basically was helpful and intervened right on time, and the prosecutor referred our requested cases to pre-filing diversion. That has happened quite a bit actually in our practice. It's a successful outcome. It's the best case scenario you can hope for if you've been arrested and are facing the threat of criminal charges. And this is something that you should definitely talk to your lawyer and ask specifically about pre-filing diversion and what that is. So let's talk about the difference between pre-filing diversion and post-filing diversion, because there is a big distinction. Pre-filing is before charges are filed, and you need to work with your attorney and intervene right on time before the prosecutor makes a decision on filing in your case. So if you can get pre-filing at that point, that's a great outcome. That's a win. As long as you complete all the program requirements, you are pretty much guaranteed a non-filing in your case, which is a great successful outcome. And pre-filing is different from post-filing. You could still be eligible and receive post-filing diversion if your case is filed, if charges are filed against you. But that usually comes after an appearance in court where you have to go to court and there's a complaint against you. So you're now involved in the criminal justice system. You're being processed by the system versus the pre-filing stage where your charges have not reached the court. You don't have to go to court. And as long as you complete the requirements that the program imposes, then you are basically guaranteed to walk away without a criminal conviction from that arrest. How do you establish your eligibility for this program? Most counties have a pre-filing diversion program. So they're looking for first-time offenders who have been arrested for low-level offenses. If this is their first time, they have a clean history, they're not a recidivist, there's no prior encounters with law enforcement, and it's a type of offense that could be rehabilitated, for which you could be rehabilitated for, right? So if you complete certain classes, certain counseling hours, or community service, basically what it does is proof of that is provided to the officer who's supervising your pre-filing diversion, and they complete your file as successful, and they notify the DA, and the DA basically closes the file on you, and charges are not filed by the district attorney's office. So in order to be eligible, they're looking for low-level offenses such as petty theft. They're looking to see if there's rehabilitation. So if you've already done classes and community service and you provide proof of that to the DA could be more inclined to refer your case to pre-filing diversion versus affirmatively filing your case and sending the complaint to court, in which case you have to now go to court and face, the judge and be involved in the criminal justice system. So let's say two people make the same mistake and they get arrested. One of them is charged formally with a crime, and the other is afforded an opportunity at pre-filing diversion. These individuals, it could be the same crime, but they're two different tracks, have different consequences, right? Because of what's happened in their case. One person got pre-filing diversion, the other didn't, and the other has to now go to court and face the criminal proceedings against them. So the person who granted pre-filing diversion, they get to benefit from this idea that they don't even have to go to court. They don't have to stand in front of the judge. They don't have to face a criminal complaint. They just complete the requirements, and their record reflects that they were granted pre-filing diversion. Their record does not reflect that criminal charges were filed against them, versus a post filing individual who is facing criminal charges might have a completely different outcome in their case. They could end up being convicted of the charges. They could end up pleading to reduce charges, or the charge could, for whatever reason, later down the line be dismissed. But the pre-filing diversion person doesn't even get to that disposition, because there's no case that's filed against them if they get pre-filing diversion and successfully complete all its terms and conditions. So it's a great benefit. It has immigration consequences for a lot of folks. And we all know that immigration laws are changing very rapidly, and the enforcement of immigration is changing rapidly nowadays in our times. And pre-filing and diversion and file charges could have a meaningful difference, or could make a meaningful difference and have consequences depending on the individual's immigration status. So as a prosecutor, I reviewed requests for pre-filing diversion, and the first thing that I looked at was there violence involved, right? When I'm reading the police report and there's allegations of violence, or there's injury to the alleged victim and recurring conduct, and a rap sheet that reflects prior arrests or prior convictions, to me that's an indicator of lack of eligibility for this pre-filing diversion program, because it is discretionary. And so, violent offenses and assaults involving injuries, higher level offenses, felony level offenses, those are excludable from the pre-filing diversion program generally, and that's what I looked for. And the biggest mistake people make when they've been arrested for a crime is to wait and see what happens to their case. They miss that really important and urgent window opportunity where they can, if they engage with a lawyer who knows what they're doing at the right time, at just the right time, they could potentially benefit from this pre-filing diversion. Sometimes the DA automatically refers the case to pre-filing diversion, but most of the time they don't. They end up making a filing decision with file charges, and now you have to go to court and fight that case in court, or come up with a defense to those charges in court. Whereas with pre-filing, obviously the benefit is that you don't even get to court, right? So it's really important to not make the mistake of just sitting back and waiting to see what happens to your case. So it's important to engage with a lawyer, talk about your options and how you might be eligible for this pre-filing diversion program. At Night Law, we don't just defend clients. We step in early, we do active and preemptive investigation, and we build a strategic defense that keeps in mind our clients' priorities for their lives, their careers, and their families. So we provide a very holistic approach to our clients in defense that caters to their needs and also maximizes the best possible outcome in their criminal case.